take your Saturday afternoon off from me. Beyond the call of duty, I suspect there's other reasons that you must do this. But it's, hopefully we'll spend a good 15 minutes together. It's important, I think, that we have a good interchange. I didn't realize that we had raffle tickets in my tour class last night. We had great interchange, and I wasn't able to reward them with these raffle tickets, which I understand are now available, and they just gave to me. But here they are. So, actually, you benefit, because I guess I have 15 of them that were supposed to be distributed between 3 classes, and now they'll be distributed between 2 classes. So, I guess I have to make the hard decision of who contributes the best, the most, and we'll deal with that. We'll deal with that later. It's great to be back at DU. I had the pleasure of speaking with Professor Corey Chetty's class last fall, his criminal law class. His criminal law class. He and I taught that, and then this past spring, I taught in his constitutional law class on search and seizure. Today we're going to spend a little bit of time talking about ethics and how a lawyer, particularly a litigator, deals with some of the issues that arise from the ethics point of view. There's no way to do it in 50 minutes. Believe me, it's a very complicated area. Law firms like mine have full-time lawyers working on those issues. So we'll just scratch the surface, but I think we'll hopefully have an interesting time with it. Let me start simply, though, by telling you a little bit about myself, so you have a frame of reference. I, like Professor Cicchetti, graduated from Duke Law School. He, a few years later than I graduated in 1976. I've been practicing for 35 years, the same law firm in Washington, D.C., law firm Williams and Connolly. You may have heard of it. We are litigation specialists. We're unusual in the sense that we only have one office. We have about 250 lawyers, but we only have one office. So many firms today are what we call mega firms with large numbers of lawyers, and they have offices all over the world. But we sort of have gun will travel, and we're on airplanes a lot, and we go to where the problem is. We tend to do what we call bet the company kinds of cases, real serious, one-off matters. And cases that you may have heard about, we represented President Clinton in his defense of his impeachment in the Senate. We represented Vice President Cheney in the Valerie Plame investigation. We represented Senator Stevens of Alaska in the criminal case there, and were able ultimately to bring a lot of attention on that trial. And as you may remember, prosecutorial misconduct occurred in that case. In any event, we'll talk a little bit more about that, and I hope actually that we'll have some time and we can talk about anything you want, about law, about law school. I'm happy to do that. As I said, I do want you to ask questions, and let's have some real discussion. Before we get started, though, I'm curious, how many of you are thinking about getting a law degree after you graduate from DU? Okay, and how many of you are thinking about getting an MBA? Okay, good number. Anybody thinking about getting both? Okay, all right. You know, it's interesting because I ask this because there's always been a bit of a friction between lawyers and business people. And I know this personally because my father was a businessman and my 2 brothers have taken over the family business, and I'm viewed as the black sheep of the family. They don't particularly care for lawyers. Generally, business people view lawyers as the people who say no. You know, we're Dr. No. You can't do this, you can't do that. We never tell them supposedly what they can do. Now I must tell you that I think good lawyers do tell clients what they can do, but it is our responsibility to make sure that the client understands the risks that they're taking. You know, business people have questions about lawyers. Lawyers sometimes think, well, gee, businessmen, you know, they're just out for themselves, out to make the almighty buck. You know, they're really not quote-unquote professionals like we are. We have a code of professional responsibility as lawyers. You know, here it is. This is the Colorado one. It's not the whole book, but it's a good 100 pages of it. You know, we have rules that in every jurisdiction, every state we practice in has these rules of professional conduct. But you know, as Professor Cicchetti said last night, if you were there at his talk, he said at the heart of all sorts of ethics rules are really sort of basic issues of integrity and values, and that's the same in the law. You know, people think rules clarify things. I must say to you, as a lawyer, I find that rules don't necessarily clarify, they complicate, because the more rules you have, the more exceptions and the more variations and the more difficult questions you have, and that's what lawyers do. I mean, we sort of parse our way through these and try to come to tough decisions. And the rules of professional conduct are no different than any other rules, because as you'll see, there are conflicts within those rules. And let me just give you an example as we start. I want to read to you from the preamble to the Colorado rules, and it talks a little bit about these conflicts. It says, a lawyer's responsibility as a representative of clients, an officer of the legal system, and a public citizen, those three roles, are harmonious, or are usually harmonious. Thus, when an opposing party is well represented, a lawyer can be a zealous advocate on behalf of a client and at the same time assume that justice is being done. So also, a lawyer can be sure that preserving client confidences ordinarily serves the public interest, because people are more likely to seek legal advice and thereby heed their legal obligations when they know their communications will be private. In the nature of law practice, and here's the other word, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. So you see, already the rules themselves are recognizing that it's not easy, that there are conflicts within them. And then let me read to you just very quickly from a speech that was given by a lawyer in Washington, the fellow named Bob Bennett, well known, formerly at the law firm of Skadden Arps, now at, where is he now? He's now at Hogan and Lovells. And here's what Bob had to say about this, and I thought he put it well. He says, we are instructed by our codes of professional responsibility and told by professors, legal scholars, and mentors that we lawyers, as guardians of the law, play a vital role in the preservation of society, that we have an obligation to adhere to the highest standards of ethical and moral conduct, and that in our words and deeds, we must promote respect for the law and our profession. We must deal candidly with others, and we should use our education, skills, and training to do public good. Finally, we're instructed to be zealous advocates on behalf of our clients. I agree with all this, he says, and I have tried in 30+ years of practice to honor these goals. And here's the important part. But I would be less than candid if I said it was easy. At times, there is some moral conflict between these roles, as they do not always work in harmony. The zealous advocate often speaks and acts in ways that to many are morally questionable, less than candid, and do not promote respect for the law in the eyes of the public. And, you know, lawyers are the butt of, you know, sort of used car salesman types of jokes, and I think that's in large part why, because so much of what we do sometimes butts heads with what the common view is of what the right moral decision might be. So let's get right to this issue of moral conflict in matters that we as lawyers face. And I want to take you right to one that Professor Cicchetti mentioned last night. He sort of said it was easy. On the surface it may be easy. We're going to dig into it a little bit more. And that's with the issue of how do you represent a quote-unquote guilty client. And so I want to look at two of the rules that are in the Code of Professional Responsibility, just as, again, I'm telling you, we're going to just scratch the surface here. So this is a very top-level view. But I want to go into just take a look at two of these rules and show you, let's discuss these conflicts that we're talking about. Okay, so the first is Rule 1.6, which speaks to the confidentiality of information. And it reads as follows: a lawyer shall not, that's a mandate, obviously, shall not reveal information relating to the representation of a client unless the client gives informed consent. Obviously, the attorney-client privilege mandates the confidentiality of communications and conversations between a lawyer and a client. Why? Because we want to encourage the free flow of understanding and ideas so we as lawyers can fully represent you. Now, I tell my clients oftentimes, if you don't tell me everything, you know, I'm not the one who's going to jail, you are. If you don't tell me what you understand, what you know, there are landmines out there. It's a dangerous world. And I'm gonna step on that landmine. And it's gonna blow up. And who's gonna suffer the consequences? You. So be candid with me, the conversations are confidential. Okay, we have that on one side. Then we have Rule 3.3, and that's called candor toward the tribunal. And it reads as follows: a lawyer shall not, again a mandate, knowingly offer evidence the lawyer knows to be false. Okay, the rule, and that rule of course itself makes sense, just like the other rule, because you're trying to maintain the integrity of the truth-seeking aspects of the system, particularly of the adversarial system. So, what do you do with the client who wants to take the stand, take the witness stand, testify on his own behalf? And let's take two separate examples here, two different issues, or two separate ones. First, you think the client's lying. You think the client's lying. And the second, that the client has admitted to you, specifically, that he or she committed the murder. Let's use that as an example. All right, so let's take the first one. You have a reasonable belief, based on your own investigation and your work in the case, that you believe the client to be lying. Can you put he or she on the witness stand? Who'd like to take a shot at that one? Come on. Yes.
Probably not, because then if he gets up there and the interrogator starts asking him questions, he's gonna it'll be in his face that he's lying.
In his face, but also in the jury, in what you're saying,
Yeah.
The jury will believe that he is lying.
Yeah, like I think if you're on the witness stand and you've been lying to your lawyer, it's gonna shine through that you were lying the entire time, and that's really gonna shoot you in the foot.
Okay. Keep in mind as we discuss this example talks about my reasonable belief as a lawyer, right? The client hasn't admitted to me, but I think he's lying, as opposed to the next hypothetical we're going to talk about where the client has admitted it. Any other thoughts on whether you can put that client on who you reasonably believe to be lying? Yes, sir.
That second one that you were talking about, where you can't put false evidence up.
Yeah.
That's what I'm thinking. Like if you have a reasonable belief that he's lying, then putting him on the stand to lie would be putting false.
Yeah, and let me read, no, it's important that you're following the rule, right? You're following that 3.3, but let's go back to that for just a second, okay? And what did 3.3 say? 3.3 said, a lawyer shall not knowingly offer evidence the lawyer knows to be false. Okay, and we're talking about a distinction here between reasonable belief and knowledge. Okay, who else wants to take a shot? Yes?
You should wait to see what the evidence shows, because the evidence will go further than just having that reasonable belief that your client is lying.
And do you think a lawyer will quote unquote know based on this other evidence, or does he need to hear it directly from his client to quote unquote know? You understand what I'm asking?
Yeah, he needs to see the evidence.
So you think a lawyer could know, short of his client admitting it? Okay. Anybody disagree with that? Anybody disagree with that? Yes, sir.
I think that you can only really know it as a lawyer if the client tells you.
Mm-hmm.
So if he confides in you and tells you, then you for sure know. Because I mean, evidence, there might be strong evidence towards something, but if, like let's say he was framed very well, then yeah, all evidence said he murdered someone, but if he didn't, then he didn't.
Okay. All right, we've got two diverging views here. Let's take a little bit of a vote. I'm curious to see what's your name?
Amita.
Amika, and yours?
Austin.
All right, we're gonna go with, all those who think Amika's approach is the correct one, just give me a show of hands. Okay, and Austin's? All right, well, that truth will out. Austin is correct. These are tough calls, but the fact of the matter is that the practice has been, and I guess I should say the better practice is that where the lawyer does not know, where the client has not admitted, the lawyer can put the witness on the stand, And that's where, of course, the adversary system comes into play, particularly, because there you, don't forget, you've got a prosecutor working for the government, whose duty it is to bring out the best of his or her case, and then you have your case, and you have to, remember we talked about zealously defend your client, and when those two come together, there's a jury of 12 in the box who's gonna make that ultimate decision. And it's their job to make the decision of guilt or innocence. You know, it's not your job as the lawyer unless the client, and it's never your job as a lawyer, because ultimately it's gonna be the client. If the client tells you he's guilty, then he's the one who's made that determination, not you. These are tricky. Now, oftentimes, well, not oftentimes, in some cases, in Colorado, I'm not a Colorado lawyer, but I believe in Colorado, if you know the client, in other words, the client has told you, you cannot absolutely put him on the stand. And then then it's difficult. What you have to do is try to convince him or her not to take the stand. Explain to them, hey, look, you know, you're putting yourself in real jeopardy here, because the judge is likely to really whack you if he knows you're lying, and that's absolutely the case. I mean, you see it time and time again in sentencing, that if you put a witness on the stand, you put your client on the stand and he comes across as a liar, you know, his sentence is gonna be a lot stiffer. And you basically then, what you try to do is convince him, look, let me argue reasonable doubt. Let me argue that the government's witnesses haven't met the standard of proving that you're guilty beyond a reasonable doubt. That's their burden. Yes, sir?
Are you inclined to, like, represent a client after they've told you that?
Well, after they told you they're guilty, yeah, I guess I'm a believer generally, there are cases I've turned down. I'm generally a believer in the system, and that a lawyer has an obligation to the system to represent. Everybody deserves a defense. Now, that doesn't mean every lawyer has to take every case. Clearly, there are cases that we've turned down over time. And in those situations, what I will do is make sure that the client gets a lawyer. I will never leave somebody out there without a lawyer. I think I have an obligation to, if I don't want to take the case, at least get him or her to another.
So, but like, what if you like agree to represent them, then they tell you?
Well, then getting out of a criminal case from the court is very difficult, and that's why we are very careful when we take our cases, particularly in criminal cases. But you should what you should do, if the client is not going to take it, let's take it further. So you try to tell the client, don't testify. The client insists, he's got a constitutional right to take the stand. Then this is where it gets really tough, because you can try to withdraw, but the court's unlikely to let you do that so close to trial. Then, and this is where I was going, some states allow you to let the witness take the stand, but not quote unquote vouch for him. And what that means is that the witness takes the stand and he sort of narrates, he just sort of tells his story. You know, I call Austin to the stand. Okay, Austin, you're on. You know, instead of the normal way in which there's a question and answer, it's a narrative. And that's a signal to the court that you are not vouching for this witness. But there are some states where you can't do that. And that's where, and then what you do is you try to tell the judge that you've got a problem, but it's very tricky because, again, you're bound by Rule 1.6, which remember, what did Rule 1.6 say? You can't disclose, right? So if you can't disclose, what can you tell the judge? Very little. So the point being that you try to maneuver around that, telling the judge as little as you can, but letting him or her recognize that you've got a problem with a client who's lying and that you don't want to put him on the stand. What will often happen is the court will have an evidentiary hearing, and if he determines the client definitely wants to take the stand, intends to lie, and by this point I must tell you as a practical matter, there are very few clients out there who are going to take it that far, because when they hear the judge telling them, I'm going to really whack you, it's usually over. It's usually over. All right, but anyway, so that's not a typical issue, but I mean it's a difficult issue. And it's a little, with all due respect to Professor Cicchetti, who's now in the back of the room, it's a little more difficult than the simple example he gave last night. Yes?
But so if the client tells you, like, I am guilty, isn't, like, if you go to court and argue that he's not guilty, isn't that lying?
Yes, you can't, no, that's the point. If he tells you, this is the difference. If he tells you, yes, you cannot argue, you can't argue the fact that he doesn't think he's guilty. But what you can do is, if you don't put him on the stand, Then what you can argue, and can argue vigorously, is that the government hasn't proven its case beyond a reasonable doubt. You can poke holes in the government's testimony. Don't forget, guilt or innocence is what is not what the individual did in the legal concept. It's whether the government can prove it, and that is a and a lot of people have a very tough time with that until they go to law school. But there's a reason for it. It's the famous reason of it's better to have one guilty person go free, or 10 guilty people. I'm sorry, 10 guilty people go free than to have one innocent person incarcerated. And I believe it. Yes, sir, in the back.
Explain this. I just came in, so I'm lost. The jury wants to hear him, though. The jury wants to hear the defendant say, "I didn't do it." That's a problem.
Yeah. Well, we talked about this. Under Rule 3.3, the duty of candor to the tribunal, and that trumps because the tribunal cannot sponsor itself. It can't support false testimony. So if it's a knowing, again, we go back to this issue of knowing, as the rule requires. You have to know. And if the client admits it, then you can't put him on the stand. The jury doesn't get to hear it. Yes.
So wouldn't it essentially be admitting guilt of your client by not necessarily saying that he didn't do it, but by saying, well, your story's wrong? Isn't that almost in a way admitting guilt because you're not necessarily allowing your client to defend himself?
Let me make sure I follow what you're saying. In other words, by not putting him on the stand.
Yeah, but well, that and just by not defending his case, but by saying that the
Okay. I think a good lawyer can argue to the jury that the government hasn't proven its case without necessarily using the words "my client didn't do it" and still getting that point across. Yeah, I mean, and most lawyers, even if the client, even if the client takes the stand, I mean, a perfectly truthful client, it's rare to say my client didn't do it. I mean, it's really more of a phraseology than anything else. Yes, sir. Yes, ma'am. I'm sorry.
Isn't it like kind of obvious when you don't put your client on the stand? Isn't it sort of obvious that they did it?
It's interesting. That's a good question. As we do more and more sophisticated white collar work, that's what we do. Oftentimes there are many reasons why you wouldn't necessarily want to put a witness on the stand. For reasons that have nothing to do with the actual crime that he or she's been charged with. There may be collateral issues that they've been involved with that you don't want to come out. That would, they may not have been the most upstanding person during their life, but they didn't do what they're being charged with, right? And prosecutors love to bring in all this other dirt, so when you put them on the stand, you sort of open them up to that. So there are reasons, and often, and sometimes the government, sometimes the government puts on a very weak case, and you can score more points, but you're just showing how weak it is. And jurors, I believe, in my experience, take their responsibility very seriously. So don't forget it. You have an opportunity for what we call an opening statement before the witnesses come on the stand. And you tell the jury at that point, well, even before that, when the jury's being selected, you as lawyers oftentimes, depending on the jurisdiction, have what we call the opportunity to voir dire, to ask the jurors questions. Do they know about the case? What do they know? Do they have any prejudices, et cetera, et cetera? And you remind them that they have an absolute obligation that if the evidence doesn't meet the standard of beyond a reasonable doubt, they must acquit. And you ask them, can you honor that? Can you live up to that? And they go, yes, 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 yes. Well, it's at the end, in closing, when I show them the government hasn't, even though I haven't put my client on the stand, the government hasn't met that burden, and I demonstrate. In other words, I say, look, here's the requirements under the law of what it takes to prove murder, right? And you have to have the intent, et cetera, et cetera, et cetera. And here's their evidence, and you take them through the evidence, and you show they haven't met it. I'd rather, oftentimes want to do that than take the risk that just because my guy's been, convicted of a million other crimes, okay, but didn't commit this murder, to put him on the stand. Yeah.
Do you have an ethical? My problem here is he admits he's guilty.
Hmm?
You don't put him on the stand. You poke holes in their story. Don't you have an ethical responsibility to upholding the law and the system of law? To technically put him behind bars because he admits his guilt, things like that. So
Sure. think what, the point is that I'm just one player in this system of justice, okay? And I don't control the whole system of justice. There are various players who have various responsibilities, right? So in this case that you're describing, don't underestimate the power and the responsibility of the prosecutor, right? It's his or her responsibility to lay out how heinous the crime is and the strong evidence that they may or should have, and I believe should have before they bring that charge. And if they have that evidence, and they also wrap themselves in the flag, the American flag and the Colorado flag, and they have a lot of power in that, before that jury, the system should generally work out. And so, in that sense, I can rest comfortably knowing that I have zealously advocated for my client, but if I have reasonable belief, it's not, I can't know it, but if I have reason to believe he's guilty, the system will generally take care of it.
But if he tells you
If
directly.
he tells me, I won't put him on the stand. Now, if he tells me directly, I can't, here's what I have to do. I have an obligation, don't forget, the government has to prove it beyond a reasonable doubt, and I can raise the question, have they done that? Again, it's not, even if he's done it, that's not the standard under the standard is, can the government prove it? And again, that goes to the issue of, you want a government out there that can't prove a case, but is putting people behind bars. And that's where you get these very difficult moral and ethical issues, and that's why we're here today. Yeah.
I feel like in that case, it'd almost be more ethical to not take the case if you think that your client is guilty.
Yeah, you're absolutely right, and you're absolutely right. And the trouble is, there are various issues. One is that early in a case, you haven't had the opportunity to do the kind of full investigation that you might otherwise do. And there are many lawyers, unfortunately, who, need to make a living, and that's how they make their living, taking just about sort of everything that comes down the pike. Yes.
If you represent a client and then can he drop you at any time?
Absolutely.
So if he drops you after disclosing that he was guilty, can you take the stand?
I'm sorry, can he take the stand?
Can you take the stand?
Oh, and testify, I guess? No, absolutely not, because it is privileged. It is a privileged conversation. No, absolutely not. Now, it's unlike the court will not be happy, and will question the individual very closely as to why he or she is dropping their lawyer at this late stage.
Right.
But that's where, oftentimes, that is where the lawyer gets out, because there is an irreconcilable difference. I tell the client, you're not taking the stand. The client says, I'm taking the stand, and that's where you ask the judge to let you off and let you out. But in that course of that conversation is where the client learns that he's gonna get whacked. I think there's a question back there, Liz? Okay. All right, let's move on. Got a few other sort of issues that we want to address, and then we'll have an opportunity for some more questions. Another difficult issue is, can you represent multiple clients in the same matter? All right? Multiple clients in the same matter. Let's first talk about criminal case, and then we'll talk about a civil case. All right, just to mix it up a little, let's first talk about a civil case. We've been talking criminal. Let's talk about the civil case. You're all business types. Let's take a relatively easy example of you and your best buddy want to set up a partnership, okay? And it's going to be a partnership that's going to some high-tech deal where one of you has got a lot of money, and the other one has a brilliant idea that's going to be the next Apple. Okay, and you come to me, a corporate lawyer, you come to me and you ask me to put this partnership together and to represent the partnership. Can I represent both of you in that establishment of the partnership? Who's got some thoughts on that? And let me give you a little bit of guidance here, the idea that a lawyer is to zealously represent his client. Okay, yes, sir. Oh, I'm sorry, yes, sir.
I would say probably not, because if, like, while making this partnership, the two of them butt heads, how are you gonna decide which one to, like, side with and help out?
Are you just like mediating in between the two parties? Because they had like for instance the NFL,
Mm-hmm.
the player that they had like one mediator, right? For and what's going on with the NBA right now
Yeah.
as well.
Yeah, a little bit different, bit different, that's where you have two sides, and this often happens let's just talk about this for a second. This happens oftentimes in disputes, where you've got one lawyer, each lawyer representing opposing parties, there's not one lawyer representing both parties, but they then retain a mediator before it goes to court, and that individual is to, as you say, mediate, to try to get the two sides to resolve their differences. He or she doesn't have a client, okay? Unlike you, the lawyer, even though it's a lawyer, you don't have a client as a mediator. You represent the situation, so to speak. You're there to try to go to party A and say, hey, look, party B is willing to do this, it might be in your best interest to do this. They go to party B and say, look, party A wants to do this, it might, can you guys try to, basically a facilitator, but it's really not a lawyer in the advocacy sense of having the responsibility to zealously represent their client. There's a difference between, even though the mediators are often lawyers. Who hasn't had a chance? Yes?
If they have a contract saying that they're gonna do this partnership together, would you be able to represent both of them, and that they're agreeing to?
Well, that gets into an interesting question, and one that I wanted, which is informed consent. In other words, where you have two people come together, or it doesn't have to be two people, in any situation, where you have the potential for a conflict, which is really what we're talking about here. There's not an actual conflict. You guys come together, you're best buddies. Hey, world's great, life's gonna be wonderful, we're gonna make a lot of money together. But the lawyer has the responsibility to say, well, wait a minute. There is a potential conflict here. As you say, life could change, and you could have a little bit of dispute about, hey, you're making too much money for this idea, which is from my idea, and why should it be 50-50? Hey, my idea is worth 75% of this, etc. But that's where you have to have informed consent. That's where you have to disclose to these people before you take the case. Look, yes, I can represent both of you, but should there ever be a time when there comes to be a difference between you, then I've got to withdraw and I can't represent either of you. Okay? Now, when you have multiple clients in those situations, what you can do ahead of time is have a contract, as you say, where there's a written agreement. And it says, okay, if I represent you and there later comes to be a dispute amongst you, here's what's going to happen. And you lay it out and everybody signs off and everybody understands exactly what's going to happen. And one of the most important things, and this is you to understand this, when you represent multiple people, there are no longer secrets between you, okay, on that issue. So, in the normal situation, you have an attorney-client privilege. What you tell the lawyer about the situation is totally secret, totally privileged. But when you represent multiple people in the same situation, then everybody has to have that same information. And that's, of course, one of the first questions you ask in a multiple representation. Are you prepared to have, your colleague, your partner, know what it is that you're telling me, because I'm representing the situation, and they have to sign off on that. So that's how you deal with that. So yes, the technical answer is you can have multiple representation, but there has to be informed consent. Let's take a criminal case for a second. All right, you've got, somebody last night said to me, let me first paint the picture. We've got a homicide, two alleged conspirators to kill the individual. All right? Can you represent both defendants in that situation? Thoughts? Now you must have seen my cousin Vinny. What happened there? Somebody reminded me of this last night. Remember that great movie? I urge anybody who's interested in being a lawyer needs to see that movie. Yes?
By judging by the movie, you can represent both.
Exactly. Now, the question is why, though? Why? Having seen the movie, why could you represent both? Do you remember?
Because that way you have attorney privileges with both of them, so you have access to more information and making it easier to try and make an argument.
Well, that's part of it, but let's take it from the perspective of the client, okay? What happens if the client has, they have different views of what happened?
So it basically kind of protects each party. So like one client can't go behind the other one's back and basically like, oh, he did everything, I was forced to do it and all that. So like if they're in it together, then everything's disclosed all between the three of them, and then there's nothing.
That's right. Okay, but anybody have any other thoughts on that? This is high risk. Obviously, you've got two or more individuals who are alleged to have murdered somebody. On the one hand, it sort of protects the person, it doesn't sound like it's protecting the person who actually did it. I mean, let's say you're there, you were sort of the unfortunate person who was in the car at the time your buddies decided they wanted to hold up that liquor store, and unbeknownst to you, they're gonna shoot somebody, right? Under this theory, you're not gonna be able to put on your own, a separate defense, right? But any thoughts on this? Can you represent more than one criminal defendant in a case like that? Yes, sir.
That way you don't have to defend from multiple sides, you only have to defend against the prosecutor.
Well, you have to, the prosecutor's coming after all three of them, right?
Yeah, but let's say if you're defending one of the, people involved, you would have to be defending against allegations from his acquaintance and then from the prosecutor.
True.
You have to defend.
True, but you owe and I don't mean to say you're saying this, but it strikes me, as I'm hearing it, you're more concerned about your role as the lawyer than you are about your ethical responsibilities to the client and what's in the best. Don't forget, the most important part of being a lawyer is the question: what's in the interest of your client, not what's in your personal interest. Sure, it's in my personal interest as a lawyer to take as many clients as I can, and they're all going to pay me, right? I'm going to get 3 times as much money, right? But what's in the interest of the client? Is it in the interest of the client to be represented by one lawyer in a multiple defendant criminal case? I heard a yes over here. Who said that and why?
Well,
Yeah.
because you would think that, like, in order for a lawyer to best represent someone, for them to have to divide their energy between 2 people and have to account for 2 different things. That way, if one person goes down, the other person is going to be likely to go down too, or your probability of getting off, you would think, would be much greater if they could focus all of their energy on just clearing up, like, your individual.
Right. So I think so what you're saying is each individual should have their own lawyer. Is that what you're saying?
Oh,
Okay. Yeah. Okay. Who would? Yeah.
I think they should have separate lawyers, because if there's conflicts once the case starts and they're, I don't know if they're trying to rat on each other or something, then there's conflicts with the lawyer, I guess, because you're now facing 2 people who are against each other within the prosecution, I guess.
Okay. Good point.
The only thing I would say, if you have 2 people that have the same lawyer, wouldn't it be harder for the prosecution because they would have to prove both instead of, because if they're coming at it together, they're gonna have to prove both beyond a reasonable doubt.
Aren't they still gonna? They're still gonna have to. But don't forget, even though there are multiple defendants in the case, the jury has to issue a verdict as to each.
True, but if they're coming at it together,
Mhm.
it's easier to lace kind of for those clients lace the information together and not separate it.
That's true. That's true. Yeah.
Well, if we decided that a lawyer shouldn't take multiple clients, it would be because there would be a conflict of interest. And the idea here is that all of these defendants have the same interest, which is to be found innocent of this case. So I would say, since there isn't a conflict of interest, that the lawyer would be fine representing multiple defendants.
All right. Well, this is where the 2 of you really come together. And the question is there a conflict of interest? And oftentimes, and my cousin Vinny, there was no conflict. These guys, arguably didn't do it, and it was clear to the lawyer based on the information, and he was able to represent them together. But generally, in these types of cases, you wanna be extraordinarily careful, if you have any sense that a client would be better off having independent advice, he or she risks. Let's say, for example, that individual had a prior conviction and risks long-term confinement, whereas one of the other clients has none. It may be in their interest to plea out to some lesser offense. Any of those sorts of issues, you cannot do it if you're representing both of them. And my advice generally is, and in today's world it's so complicated, that less is more. It's far better to, there are a lot of lawyers out there who are good lawyers who can give these people good representation. And as a team, the other thing is, as a practical matter, when there are 2 lawyers working together, it's double the energy, double the time, whereas it's one lawyer representing 2 clients, it's a lot of work. So, But the bottom line here is, it is not forbidden in a criminal case to represent both clients. The only time it is forbidden, let me ask you this, when is it forbidden, whether civil or criminal, when would you think to represent two individuals at the same time? If this it may be so obvious that you're missing it, then that's, yes, in back.
You know when it's gonna be, and when it's
If you know, that's possibly, yeah, but this, that,
I mean, wouldn't it be just like you said, conflict of interest, if there is a conflict?
yeah, and it would be in this situation, I'll tell you in a second, yeah, yeah.
It's the plaintiff and defendant.
That's right. So basically, it's talking about directly adversarial. That's exactly right. If you're adversaries, you can't be on both sides of the same conflict. You can't represent the husband who's suing the wife at the same time you represent the wife who's suing the husband. Okay, so that's, but you're right. At that point, you clearly have a conflict. So that answer is correct as well. All right, let's time's flying here. Let's go into let's turn to the business world. Okay, think about this as in the business context, you're representing a public corporation. Okay, we all know that public corporation, you issue stock, and the public is allowed to invest in your company, and the corporation itself, of course, doesn't, the corporation itself doesn't speak except through the individuals who are managing that corporation, the executives who are running that corporation, and the board and its board of directors, right? All right. So you learn of some wrongdoing by senior management. You're the lawyer for the corporation. Got information that's serious misconduct by senior management who are running the corporation. What do you do with that information? Don't forget, remember, let's go back. We have this issue of confidentiality, right? If your client tells you information, you have to maintain its confidentiality. You just learned of serious wrongdoing by senior management in the corporation that you represent. What do you do? Thoughts? I told you these weren't going to be easy. These happen every day. Yes.
Would you just focus more on poking the holes into the prosecutor's case again and making sure they don't take the stand?
All right. Now this is before. Okay. This is before. Let's fair question. This is before there's been a prosecution. Okay. You're a corporate lawyer representing the corporation. You hear of senior management who's involved in wrongdoing. You have this information. Can you sit on it? What do you do with it?
You're supposed to, who are you representing? You're representing the corporation, who are the voices of the corporation, the rest of the board, things like that. If one individual in the corporation is doing something wrong, would you bring that up with the rest of the board and things like that, because they are the voice of the corporation?
Okay. That's a good point. Let's hold that for a second. Any other thoughts? Yes.
Could you just simply advise senior management to change their ways so they don't end up being prosecuted?
Another good point. Another good point. Yes, sir.
And maybe further investigate it to make sure the facts are 100% correct, and then take action from there, I guess.
Yeah, that's somewhat similar to what I think this young lady is saying here, right?
Yeah, I mean,
Right. Oh, well, you're on track. You're on track. Again, because this is gut instincts as far as what's morally right. Do have a good influence on the law. This is exactly what you do. And think about it this way. I mean, this is a very tough issue because corporate lawyers are dealing with senior management all the time. We have very close relationships with senior management. So it's very tough to just throw them in. But ultimately, you have that responsibility because it comes down to who you represent. Who is your client? You have an ethical responsibility to your client, right? Everybody has a right to a lawyer, but you can't be the lawyer to everybody. And then we talk about conflicts, and here you are obviously going to have a conflict between the corporation as a legal entity and senior management. So what do? You go to senior management, right? And you say, after having done an investigation, look, guys, this is serious misconduct. You got to clean up your ways. You've got to change this. We got to get this cleaned up. And hopefully they'll say, you're right. This was a mistake. Let's clean it up. We report it, etc. And then we do that. But if they don't, then you have an absolute responsibility to what we call report up. How many of you heard of Sarbanes-Oxley? Have you heard of the Sarbanes-Oxley law? You can tell me what it is. Yes.
But I'm not, like, I just know parts of it.
Okay.
That the CEO and the CFO have to sign off on legal statements to prevent, to the accountability there.
Right, that's part of it.
After, like, Enron, things like that,
Mhm.
where they kind of got off the hook more so than they should have, because they were letting things go on and not taking
Right,
responsibility for it.
That's absolutely right. Now, after following Enron, WorldCom, Arthur Anderson, when there was a lot of attention focused on the fact that the corporations were not paying close enough attention to their financial disclosures, CFOs, CEOs were required to sign off. But it's not just that responsibility. It's a much bigger law, and it swept up lawyers for the corporations as well. And all of a sudden now lawyers are also sort of policemen, and lawyers are being asked and being required. Otherwise, they lose their ability to practice before the Securities and Exchange Commission, SEC, to what we call report up. So in this instance that we were talking about, where senior management is involved in wrongdoing and they don't clean it up, then we as lawyers have to report it up. So we first go to our first responsibility is to the general counsel of the corporation, and if action isn't taken there, then to the chief executive officer, and if satisfactory action isn't taken there, we got to go to the audit committee, the various other committees, and ultimately the board of directors. Now, question for you is this. Does anyone find this troublesome in the sense that, on the one hand, we're being as lawyers, and put yourself in the position of a lawyer for the corporation, you're being asked to be the watchdog, almost, the policeman for the government. At the same time, you have your role as being a zealous advocate for the corporation. Anybody find that dichotomy troublesome? And if not, why not?
Well, I mean, you're still being the watchdog for the company as well, even though you're being the government aid, just because you're making sure that the company's gonna be long-term healthy, not just the short term.
Okay, good point. Any other thoughts on this? Yes.
Well, it's almost like what better person to be kind of watching over everything than the person who's supposed to be, getting them out of trouble if they get into it, kind of thing,
Yeah, but what about, think about it also though, I mean, corporations as it's an entity, you have a responsibility for that, but do I want to be the watchdog for my clients generally? I mean, they come to me and they tell me their warts and all, I learn things, and I sure hope I'm not the one who has to, turn them in, we were talking before about whose responsibility is it, the prosecutors, the governments, to make a case beyond a reasonable doubt. But let's hold that thought, because you're close as well. You're hot on this issue. All right, any other thoughts? All right, well, the fact of the matter is it goes back to who do you represent. Again, very basic issue. You're right, you represent the corporation. This young lady was right as well. Because you represent the corporation, what's in the corporation's best interest? What's in their long-term interest? And their long-term interests are to make sure that they've got employees who are doing the right thing, and the corporation survives and is successful, and the public continues to invest in it. So that sort of troublesome dilemma ultimately can be sort of worked out by the fact that you represent the corporation and not the individuals. Is this class over at 2:10? All right, let's quickly get to the last one here. I'm sorry, we're running up against this so tight. Now, the last issue is, what do we do about these individuals, these senior executives, right? That you don't represent, but that you've got a very close relationship to, and all of a sudden now you've reported this up, and the corporation says, okay, we better do an investigation. We're going to do an internal investigation. All right, so I'm the lawyer for the corporation, and I go to you, the individual, the senior management member, and I say, we're conducting this investigation. I want you to tell me what's happened, that we have a privilege, the corporation has a privilege, so feel free to tell me what's happened. Do you go in there and talk, or do you get a lawyer? I'm sorry?
This is saying you're friends with the people?
Well, you're certainly acquaintances, and you've been working with them, but you don't represent them. I mean, again, yes.
I don't know if this is what you would do, but I think that as long as you know that you wouldn't have a conflict of interest yourself, and that you're like friends with them, and you'd want to help them out more than take your work seriously, I guess. And like, I don't know, if you're gonna defend your friends, then you put a lawyer.
No,
I guess it's kind of
Well, I think your point is well taken. This is, never, you can't treat this as friendship. This is business, right? So, I mean, any thoughts about whether, if you're the individual, like, put yourself, you're the senior management. Are you gonna talk? Or do you want a lawyer? Yes.
I'm gonna want a lawyer because I know your, like, duty and best interest is the entire corporation, not myself. And I need someone to help represent myself.
Okay. And even in the face of the likelihood you're gonna lose your job. Corporation certainly has the right, if you don't cooperate, to fire you.
I mean, I think I would still get a lawyer just because I wanna make sure that I'm doing the right thing, because like I said, like, your main focus is the entire corporation. You're not gonna wanna be helping the corporation figure out what I'm doing and helping me figure out what I'm doing at the same time, cause that is a conflict of interest in some sorts.
Well, I think, I'm gonna cut it short here only because I wanna let you guys go. The fact of the matter is you're right, but the additional reason is you don't wanna go to jail. You want a lawyer there to protect your interests. The fact of the matter is if you've done wrong, the corporation is going to say, hey, this is your problem. They wanna get off. They're gonna, that quote unquote privilege, that's their privilege, by the way. Be very careful here. When the corporation says to you, well, we have a privilege, you ask them, whose privilege is it? If it's not your privilege, it's their privilege, they can waive it at any time. And corporations today are waiving it all the time. When the government comes in and says, we are considering indicting you, the first thing the corporation does, unfortunately, is waives the privilege to try to curry favor with the government, and then they throw you under the bus. So get a lawyer. What it comes back to is that lawyers and businessmen can and should work together, and here's a good example of one. Thank you very much. Sorry to